Welcome, everybody. My name is Jamie Bilsbach, and I'm the Center Director for the Central Mountain Small Business Development Center. And joining me is my colleague, Devin Dean, as well as our presenter, Nathan Lawrence. And I had the great pleasure of meeting Nathan right before COVID when he had a meeting with me. Our center had just opened and said that he could support us with some legal advice and workshops. So I'm so happy that Nathan this year is sharing a series of 7 workshops, which are listed on the deck. And welcome. Next slide.
Hold on, sorry.
We're the Central Mountain Small Business Development Center, and our center, as well as 14 other centers, support small businesses with no-cost confidential consulting, low or no-cost training, as well as we assist with access to capital. Next slide. This is our whole network. Our center's in the middle in yellow, but we just want to make sure that you're aware that we can support you no matter where you're located throughout the state. And then we're managed through the Office of Economic Development and International Trade. So we have access and can support you with all of those resources as well. And now I'll pass it over to Nathan.
All right, welcome everybody. Thanks a lot. My name is Nathan Lawrence. I'm a small business and startup attorney based here in Salida, Colorado. We also have offices in Denver, where my partner works. My firm is outside general counsel to small businesses and startups, which means that, if you have an issue, a legal issue or a legal need as a small business or a startup, about 99% of the time we'll be able to take care of it. And we'll have a good referral for the other 1%. So feel free to reach out to us with all your small business and startup legal needs. We are doing free half-hour consultations to SBDC participants and really anybody who asks. So don't hesitate to take advantage of that resource. My contact information's here. You can reach out separately to set that up. So rather than tell you guys more about myself, which, I know some of you attended the first session, hopefully those of you will continue to attend these. I'd like to tell you something new and hopefully interesting about my firm or myself. So here's something I think you all might find interesting. We use an AI specific tool to help accelerate work product for our clients, basically to cut through a lot of the administrative research and drafting work to produce work product faster. It's called Spellbook AI, and it is legal specific. So it doesn't collect our prompts, which is very important to us. Obviously, we need to keep your information confidential. And it only references legal libraries like LexisNexis and Westlaw, as opposed to the internet in general. So just a little fun fact for everybody. And yes, we are aware of horror stories with using AI in legal context. Trust me when I tell you that we check what we get from our AI source, which seems like an obvious thing to do, but if you read the news, not every attorney does. In any case, if you leave here today feeling like you know what I'm talking about, please do reach out. I'd love to speak with each of you individually. There are a lot of, Jamie was saying before everybody joined here that, you always get an answer that depends from lawyers. And the truth is that it does depend usually on your specific situation. So what I'm telling you here today is general information. It's not specific legal advice, although, you can probably connect the dots. And I also need to note that, communications that we have one-on-one, whether it's in an intro session or in a, after you sign up, are privileged and confidential. But anything you put in the chat here, whether it's being recorded or not, is not subject to privilege or confidentiality. So if you have something that you think might be wrong, maybe wait until we're one-on-one to discuss it. But otherwise, I really welcome your input, thoughts, questions. I think I know what you guys want to know, but it's always more, I think, relevant if folks do ask some questions and get involved. All right, so today we're going to talk about building blocks of business, legal structure, liability, and tax. Before we get into that, I want to give a quick update from the last session, which was on employment law. We had a question about the Colorado Secure Savings Program and whether every employee, this is a retirement plan that Colorado is requiring employers to participate in. So we thought maybe every employer was required to participate starting in 2024, but that's not the case. If you have less than 5 employees, if you haven't been in business for 2 or more years, or if you already have a qualified retirement program, you're not required to participate in the secure savings program. If you don't know what the secure savings program is, and this is making you nervous, or you think maybe you're missing a requirement, I'd suggest that you go back and look at the last month's video on employment law and give me a call. We can talk about it later. All right, back to today's topic. I would call this topic corporate governance, but Jamie and Devin are smart and good marketing folks, so they didn't want me to call it that because we wanted you all to show up. So we're calling this building blocks of business. But the idea here is, these are kind of the basic things about how to run your business. So to protect, to take advantage of the legal structures that are available to you, to limit your liability. And then we're also going to talk just briefly a little bit on tax and give you some basics to help you at least understand the lay of the land when it comes to business taxes. Okay, so our objectives are, to identify the appropriate legal structure for your business, understand how to use that business to limit your liability, and figure out some basics. That's basically what I just said, so we'll keep moving here. Okay. So the first thing to know is, sort of a baseline starting question is, what kind of business do I need? And what do I have to do to get a business? Hopefully most of you, that are operating some sort of business already have crossed this step, but maybe you haven't. And maybe you'll find out that, a different business entity makes sense for you. And if that's the case, then, it's okay. You can change your business entity type. You can go from a corporation, an LLC, etc. We're going to focus on the most common types of business entities today, which are corporations and limited liability companies. There's a lot of other types, and I'm happy to answer questions about those, in that segment and at the end if we have time, or discuss them one-on-one. But probably 90% of you are going to end up in a corporation or limited liability company. So that's where we're going to spend most of our time. Understand that the concepts between, the general principles that we're going to talk about, the duties, the obligations, they're going to apply, pretty much across the board. So you can take this knowledge and apply it to other types of entities as well. So the first question is, what is an entity, and do I need one? So an entity is really just any organization, whether it's formal or informal. An incorporated entity is one that's registered with the state and under the aegis of state law. You can have an entity, a business entity or a business form without doing anything. You can do it accidentally even. So let's talk about that in a minute here. But first we want to talk about what is limited liability. So limited liability and the corporate structure are going to interweave here a little bit together. So we're going to talk about it now, and then we're going to talk about it after we talk about the corporate structures. So everybody's familiar with the term limited liability, but many people don't understand it. It means that the liability of the company is limited to the owners, and limited from the assets of the owners and restricted to the assets of the business. So if you have a company that features limited liability, the creditors or judgment holders of that company can't take your house personally in your retirement. If you have a company that does not feature limited liability, if an entity that does not feature limited liability, that's not true. So forming a company in Colorado costs about $50 and takes about 10 minutes. So if you haven't done it, it's probably worth doing. Forming a company and a corporation and an incorporated entity with the state creates a legal person that's distinct from you. Corporate is from the Latin corporatus, meaning to form a body. And corporations are people, and that was originally intended to allow groups of people to act in concert the way natural persons can, such as owning property, borrowing money, getting sued, and being sued. The public policy behind this, the limited liability for incorporated entities, is to encourage investment and limit risk to those who do invest. The thing to really note here is that you need to have a business entity registered with the state to get limited liability. If you're just in business with yourself or a partner and you just go out and start doing it, you don't have limited liability. So a very common example of a business entity that's unincorporated and does not feature limited liability is a general partnership. And you don't have to intend to get into a general partnership. You don't have to sign a partnership agreement, sit down with somebody. All that's required is 2 or more persons engaged in business for the purpose of profit. That's a general partnership. And partners are jointly and severally liable for all obligations of the partnership. So, think about your kid's lemonade stand. Like when she and her friend go out there and set up on the street and start selling lemonade, that's a general partnership. Now, hopefully there's not too much liability associated with lemonade stands, so we probably don't have to worry about that scenario. But imagine you and your friend come up with a neat business idea, Acme products. Let's call your friend Doug. Doug is, intelligent, creative. Maybe he's made a few mistakes along the way and he doesn't have a lot of money. You casually begin operating on nights and weekends selling Acme products. And while out delivering, Doug is in a serious accident. He's at fault. Maybe his insurance is lapped. Somebody's hurt. The damages are staggering. Because you never formed a legal business entity and because Doug was delivering Acme products, the plaintiff's going to be able to argue that you personally are liable because you are 2 more persons engaged in a business to make a profit, and Doug was engaged in a company business. So in that scenario, sitting at home alone by yourself, you might end up losing your house because your partner went out and did something rash. So this is not a good situation for most businesses to be in. If you're doing business with another individual or even between companies, understand that you may be jointly and severally liable for all debts and obligations of the partnership, and you don't have to write it down or have any kind of formal compact to do it. If it meets this definition, it's partnership. Similarly, a sole proprietorship is, the same idea, it's just you instead of, you and another person or persons. It offers no limitation on liability. And, you can't get in trouble for what somebody else does, but if you do something that incurs liability with your business, it's going to go all the way to your personal assets as well, unless you incorporate some sort of business entity with the state. A quick note, the reason I like to bring this up is I frequently get folks who come to me and say, I've registered a trade name, or I registered a DBA, or I've registered a trademark, and so I have a company. And that's not the case. The Secretary of State's website can be confusing. Guidance online can be confusing. Registering a trade name simply puts the world on notice that you're doing business under a certain type of name. So my formal business name is Rocky Mountain Legal Limited. That's the firm's name. And we're DBA. We're doing business as principal law because somebody smarter than I in marketing said that's not a great name, what you chose, and we should figure out a better one. But that doesn't mean what type of entity you have. It's just putting the world on notice that you're doing business under a different name. And so if they need to find you, this is where they can find you. So be careful if you're doing your own filings on the Secretary of State's website that you are in fact incorporating an entity and not in fact just filing a DBA or trade name or trademark.
And Nathan, can I interrupt you here?
Yeah,
so if they're filing using their social security number, they are not covered, correct? So that if something happens, they are personally liable. Is this true?
State the first part of the question over again, the part about Social Security.
filing their income and their taxes via their social security number because they're just a small service provider?
Yeah, great question. I'm glad you asked. We're going to get into this a little bit more later, but no, that's not correct. So depending on the type of business entity you have and the type of taxation you elect, you may have a disregarded entity like a single member LLC is basically ignored for the purposes of business taxation. We'll talk about that in the tax section here in a little bit. So there's two levels: what type of entity you have and how you're doing business, whether as a corporation, a general partnership, sole proprietor, LLC, et cetera. That's a factor of state law, right? And so you register that with the state of Colorado, state of California, state of Delaware, wherever. How you file your taxes is a factor of federal law. So in fact, whether you use your employer identification number, which is your tax identification number if you're a business with more than one owner, or whether you use your social security number because you're a disregarded entity, has no bearing actually on whether you are going to be personally liable under the law, under state law. That's a question for federal law, and it's about filing taxes, not about your legal protections under state law. And so that's something that most people don't really get, and we're going to talk more about. So I'm glad you asked the question. But yeah, you need a business entity filed with the state in order to limit your liability. That does not necessarily have, I mean, it's relevant, but it's not the same thing as how you're taxed under federal law. And that's a great point. Hopefully that we'll understand completely by the end. Does that make sense, Jamie? Do you have any follow-up questions, or does anybody have follow-up questions?
That makes sense, and I'm really glad you clarified, because that's one of the answers I would have gotten wrong.
Right. Well, most people do. So we're going to talk about it in a little more depth as we go. Any other questions on, and we are going to come back to limited liability and how to maintain it and talk a little bit more about that after we finish talking about business forms. Do we have any other questions on the general partnership, sole proprietorship, or the basic concept of limited liability?
Yeah, nothing so far.
Okay, let's keep chugging then. All right, so what is a corporation? A corporation is an entity having authority under the state law to act as a single distinct person, distinct from the shareholders who own it. And it features limited liability. So these two things, the blue bullets there, are the same as a limited liability company. Unlike a limited liability company, a corporation must issue stock. And there are well-developed statutes and laws. Corporations have existed since the 1790s in the United States and earlier in Great Britain. So we kind of know what we're doing with corporations, and there's a lot of history and legal precedent. They're managed by a board of directors. There's typically, significant formalities, required meetings, board minutes. They're typically have a structure that many folks know and are comfortable with. They're taxed separately, taxed as corporations by default, but that can be changed. We'll talk more about that later. And that's why you hear about double taxation. So a corporation takes in money and then is taxed on its profits, and then it pays out dividends to its shareholders, who are taxed on their profits, on their income from the dividends as well. So we call that double taxation, and we don't have that by default with limited liability companies and other forms of entities. But as we'll talk about, that can be changed. In the kind of the startup and small business context, corporations make a lot of sense for people that are looking for institutional money, if we're looking for, private equity, venture capital kind of investment. Most of those entities are going to require that you be a corporation because of the well-developed statutes, because of the formalities. They want to know, that the business is being run in a certain way. And there's some accounting issues as well with having pass-through entities that we'll talk about a little bit more later. But for now, the point is that, corporations are good for very large companies and companies that intend to become very large, and especially if they intend to do it by acquiring institutional investment from professional investors. All right, so a limited liability company. Again, the first three are pretty similar to a corporation. An entity having authority under the law to act as a single person, again, features limited liability. Unlike a corporate, I mean, it's not the exact same as a corporation. A limited liability can issue shares, we call them units, in a limited liability company, but you don't have to. It's just sort of optional. And all those are, little fractions of the total ownership of the company to track how much is owned when it gets split up enough that it's hard to just say 20%, 80%. Instead, you're saying, we're getting down to decimals, easier to track in shares. And that's really all those are. The statutes and decisions around limited liability companies are, less well developed. LLCs were first created in Wyoming in 1977. Most people think they've been around a lot longer than that. Most states didn't adopt the business form until the 90s. So there's not as much case law, but in a lot of states, including Colorado, the LLC Act explicitly requires that courts apply concepts from legal decisions on corporations to LLCs. So, probably isn't that much of a difference between an LLC and a corporation with respect to the body of law that applies. They can be managed by the members, which is what you see in a lot of small businesses where it's just you and one or two other people. There's fewer formalities. We just, everybody has the right in a member managed LLC. Everyone has the right to bind the company. It's like we're all CEO and president at the same time. Or LLCs can be managed by a board of managers, in which case it really looks a lot more like a corporate structure. And that's more typical when, there's one person really running or a group of small people that are really running the operation, and there's others that are silent investors, or when, you want to keep control, the large part of the control in a certain group or with one individual, that can be advantageous there. They involve fewer formalities. They're creatures of contract, and the Limited Liability Company Acts in most states can be overridden by the company's operating agreement, a written agreement about how to run the company, which is not required. Remember, not a lot of formalities, but a very good idea. Members do have a right to information, but the rest of about the company that they've invested in, but the rest of their control can really be limited. In Delaware, in fact, and we'll talk more about this later, we can even eliminate fiduciary duties of members and managers in a limited liability company. Limited liability companies may not be acceptable to venture capitalists and private equity investors. They may want the corporate form for the surety, the tax treatment, and so they know what they're getting. But it's appropriate for most businesses that aren't seeking institutional investment in the near future. They're flexible. They can be whatever you want, and a lot of small businesses end up tripping over the corporate formalities. There's too many. They don't actually do them, and they end up violating the law and creating issues for themselves because they've picked something that's more complex than they're actually going to follow. So LLCs are, a good idea for, I would say, most small businesses, with some exceptions. And a lot of you would say, hey, but why I want an S corp? Well, your LLC can be an S corp. Again, that's the federal taxation versus the state law tax legal entity form. Also bear in mind that you can switch between them, and you can switch between states. If you're an LLC, you can become a corporation and vice versa. And you can become, if you're a Colorado limited liability company, you can jump through some hoops and become a Delaware corporation if and when you decide, you want to go after those venture capital dollars. All right, before we move on to fiduciary duties, questions on limited liability companies and corporations? I bet there's some.
The first question is, should my LLC name be different from my business name?
So, your legal business name is your LLC name, and it needs to have the word LLC or limited or LTD or limited liability company in the suffix. So like let's say your business is Acme Products LLC. Now, you don't have to put Acme Products LLC everywhere you write Acme Products. You can just use Acme Products, but somewhere you need to indicate that it's a limited liability company so that the public knows that that there's limited liability. That's the intent of requiring that If you want to be extra careful, you could file a trade name such as just Acme Products. And then when they go look for your trade name, they'll see that you're Acme Products LLC and have all the correct information. Again, that's what I did. My business name is Rocky Mountain Legal Limited with the trade name of Principal Law. So if you go onto the Colorado Secretary of State's website and click on Principal Law, it'll take you to Rocky Mountain Legal Limited. So I guess the answer is you can have a different name, but you don't have to.
Okay, and then you said it's easy to switch back and forth, but how do, without getting into too much detail, how easy is it? Is it just filing again on the Secretary of State, or what is the
Yeah, in
process?
Colorado, it's fairly easy. There's this, it's called, you file a statement of conversion, and, you go online, look for that on the Colorado Secretary of State's website, and it should kind of walk you through it. And what you do is, you file a statement of conversion, then you file articles of incorporation if you're changing from an LLC to a corporation, or articles of organization, it's vice versa. So Colorado is not too difficult. The website's pretty good. If you want to switch to a Delaware LLC or Delaware corporation, Delaware makes it pretty hard and expensive. They like you to go hire people and support their little economy out there, which is largely based on, corporate paperwork. And so it just depends on the state. Colorado, it's not hard, but there's 49 other examples we'd have to go through to answer that fully. Because again, it's state law, right? So hopefully we're in Colorado, in which case it's not too bad.
And then I have two more questions. The first is, which of the changes, if any, between LLC and Corp, or moving between states, requires getting a new EIN?
Getting a new EIN. There's probably a better question for a CPA, but they shouldn't require a new EIN. It's the same entity, more or less. When you're moving between states and moving business forms, the point of doing a conversion as opposed to just opening up a new one and shutting down the old one is that there's a continuity of that business. And the federal identification should go with it, I believe. But I can look that up at the end here. We just did one of these, and I'm pretty sure we kept the same EIN.
Thank you. And the last question is, when does it make sense to consider being in S Corp?
We'll talk about that in the tax section, because again, this is state law types of entities, and an S election is a federal tax election. So we have a section on that. We'll get to it.
Thank you. That's it.
Okay. All right. So let's talk about fiduciary duties. This is something that we need to think about in terms of our role with our business entity as a member of an LLC, as a manager of an LLC, as a director of a corporation, as an officer of a corporation, and to a lesser extent, as a shareholder of a corporation. So what is a fiduciary? You've probably seen insurance ads out there saying, or investment ads, we're fiduciaries, that you can trust us. Well, maybe. A fiduciary is a person or entity that has the power and obligation to act for another under circumstances which require total trust, good faith, and honesty. They're responsible for managing assets or making decisions on behalf of another person or group of people. Fiduciaries have a duty to act in the best interest of the party whose assets they are managing. Right, so this includes members in member-managed LLCs, right? If we're all CEO, there's three of us, and we all have, we're all running it together, rah, rah, rah. I owe a duty to the other two members to look out for their best interests, to act with good faith and honesty, and not to, squander the assets that they've entrusted to my care. Same with the manager of an LLC. Manager is almost synonymous with a director in a corporation. It gets a little confusing. We have the same concepts between LLCs and corporations with different names. So manager equals director, member equals shareholder, and officers are in both. Officers would be the president, CEO, CFO, secretary, etc. And all of those positions owe fiduciary duties to the owners of the company, and that being the shareholders, in a corporation and the members in an LLC. All right. So what duties are owed by fiduciaries? We're talking about this in a business context. There's a lot more that we could get into when it comes to trusts and so forth. But basically the duty of care, the duty of loyalty are the two main ones that we need to discuss and understand. Again, note that members in a manager-managed LLC and shareholders in corporations do not typically owe these duties. So if you just own stock or you just own units in an LLC and you're not really operating in the business, you're not running it, then you don't have to look out for the other owners, right? So I own a couple shares of Meta, right? I'm in Facebook. Do I owe Mark Zuckerberg a duty? No, I don't. But if I was running Facebook, which I'm not, and thank God, I would owe that duty. So that's kind of the distinction is, are you running the company? Do you have control over the assets? In which case you owe these duties. So let's talk about the duties specifically. What are owed? Duty of care. So business fiduciaries, that being all these folks in the column on the left, are required to act with care that a person in a similar position would reasonably believe appropriate under similar circumstances. They should make informed decisions, avoid negligent or reckless conduct, intentional misconduct, or knowing violations of the law. That sounds pretty easy, right? And to some extent it is. You can't just ignore your business and not get in trouble for it. So I think the seminal case on this is a woman who was the CEO of a company, but she was really retired. Her son was the CFO, and he did a bunch of boneheaded stuff and just, spent all the money of the company and drove it into the ground. And the question was she responsible? And the answer was yes, because she'd signed off on a bunch of stuff and she just trusted her son and didn't really check. Well, it turns out she should have checked. She was the CEO. She didn't exercise due care and she was liable, right? The second duty is the duty of loyalty. Business fiduciaries must act in good faith and in a manner they reasonably believe to be in the best interest of the LLC and its or corporation and its owners. So that includes avoiding conflicts of interest, not competing with the company, not usurping business opportunities. Like if somebody comes to you with an idea, let's say somebody comes with, hey, I've got a great piece of real estate, and you work for a real estate company as the CEO, and you go buy it yourself as opposed to offering it to the real estate company, which would have liked to have that opportunity. That's a breach of the duty of loyalty. Note this doesn't mean that you can't make money off who you owe a duty to, but you have to be fair about it. You have to be upfront. You can't, sneak the money out. You have to tell them what the fees are and charge them up front. So, if you're a manager in an LLC, you can certainly make money, but you can't do it by siphoning funds off the side or by using the corporation's interest for your own profit. So can the duties be modified? Yes, in most states, to varying degrees, they can be modified to the extent not manifestly unreasonable. So what does that mean? I don't know. And neither does anyone else until a court rules on that specific situation. Lawmakers like kind of using these nebulous standards when setting a hard line rule might result in unforeseen circumstances, and litigators love it because it gives them something to argue about. But transactional attorneys like me kind of hate that manifestly unreasonable standard. It's difficult to give guidance to our clients, sort of a we'll know when we see it kind of assessment. So yes, we can modify the duties, but you're still not allowed to just blatantly take advantage of the folks that you're supposed to be looking out for in the business context, except in Delaware, where you can now do away with fiduciary duties completely. That might be one reason to convert to a Delaware LLC or corporation. So finally, be aware that, in case this is making you nervous, there is something called the business judgment rule. And it's a, legal principle that assumes that the directors and officers of a corporation are acting in the best interest of the company and shields those individuals from liability for decisions that were made in good faith, even if they were, stupid or made or ill-advised. That the courts aren't going to go back and say, well, you should have never invested in WorldCom. You should have seen that it was going to collapse when you used your company's money to do that. That was they're not going to make that judgment over again with 2020 hindsight. They're just going to look and see if you were acting in good faith, more or less. All right, so that's kind of a lot in a one slide. So maybe, Jamie, do we have questions? I think I saw some stuff in the chat.
No new questions.
That's no new questions? Okay. So, you probably are seeing where this is going, but the idea is, you pick your business form, you understand what your duties are, and you follow them, and then you get to take advantage of the limited liability of the business, right? So that's kind of the thought trajectory that we're following here. So what happens when, we can't, how do we get past that limited liability, right? This is a good quote from Anderson v. Abbott, 1944. It's kind of the big case on this. The purpose of the doctrine of piercing the corporate veil is to prevent abuse, right? It's to prevent you from using the corporate form to abuse the public. And the limited liability of the shareholders, and that, that's the members, that's all the owners of any business in a limited liability company or corporation, is the law's bestowal of a privilege upon them at the price of imposition of certain duties. Right, so this is the quid pro quo. You get to invest, you get to enjoy limited liability, but you have to act in accordance with the rules that we set for these entities. And if we don't, that's called piercing the corporate veil, and that's a legal doctrine that allows a court or a plaintiff to hold the shareholders of a corporation or members of an LLC personally liable for the debts or liabilities of a business entity. It also works between businesses. We have parent subsidiary. You might say, oh, the subsidiary is limited liability. Well, if you pierce the corporate veil, you can get to the parent, and it can work side to side as well, where we have two companies that are independent ostensibly, but in some cases they have the same owners, and they really are alter egos of one another. So we can pierce the corporate veil, disregard the limited liability, and go after the owners. And this is what you want to avoid, right? So it's good to know about how it can be done to avoid it. There's two main conditions. One is that, the alter ego or unity of ownership condition. And, this is sort of where the separate personalities of the corporation, the shareholders, don't exist. This can occur when the entity is used as a mere shell, instrumentality or conduit for a single or dominant shareholder's personal dealings rather than the benefit of the business as a separate entity. So this is shown often that, we're using where the funds are being intermixed. That's probably the biggest one to take away from this. If anything, it's just, if you treat your business like it's separate, and don't use business money for personal stuff and vice versa. Keep it separate and track it. That's the easiest one for folks to look at and say, this is really just the same person. They're buying groceries with their business debit card. So avoid that kind of behavior. Most of us do it at some point or another. I'm here to tell you that to the extent possible, you shouldn't. So in any case, we'll get into that more, how to prevent this, but alter ego, unity of ownership, there's really only one thing here. It's, Nate Lawrence and Acme Products are basically the same thing. And then the second thing is an inequitable result or fraud. We're not just going to do this. We're not just going to say, hey, they're commingling funds. You have to be using the entity in order to get a result that is fraudulent or inequitable. So this might be where you borrow a bunch of money from a bank, let's say, or from another individual. Probably more, people don't feel that sorry for banks. So let's use another individual. You borrow money from your grandma and you borrow it from the business. You start an LLC, but you just put that money into your own account and then you spend it on a new car. And then when your grandma says, hey, it's time to pay me back, you say, oh, I'm sorry, the business is out of money and we don't have it. Well, the courts might say in that situation, you just basically use the corporate form to steal from your grandma and buy yourself a toy. So we're going to ignore that. Because it'll result in an inequitable result. It is an extraordinary remedy. Courts will only apply this when, required to achieve justice. Nobody's looking to go out and trip you up and try to do this. But, what'll happen is if you end up not being able to pay somebody or not, being able to meet an obligation, maybe you get sued and, and your business doesn't have enough to cover the obligation. You say, sorry, I don't have it, then they're going to start looking to see if they can get at your personal assets. That's when this comes up. Nobody's out there looking for you, but it will, potentially can be reviewed in the event of, a legal dispute. So how do we maintain the corporate veil? We're trying not to let the corporate veil be pierced as business owners. Again, separate financials, separate bank accounts, commingling is the biggest one, and the easiest one to avoid. Capitalization, the corporation should be adequately capitalized or funded. If the company's intentionally undercapitalized, it could be seen as a sham set up just to shield the owners from liability. So if you're out there doing business and you're taking out lines of credit, say to buy a $500,000 piece of equipment or something like that, but you don't even have enough money in the bank account to make the first few payments on it, that could be seen as undercapitalization. It depends a lot. In a services business like mine, where you're really just giving advice, there's not a high capitalization requirement. But if, for instance, there's repeated monthly expenditures that you're going to have coming out and you don't have enough money in the bank, that could be undercapitalization. Again, it's one that's probably better discussed on an individual context. Record keeping, I don't know if this made it in, but it's important to keep up-to-date records, including minutes of meetings, resolutions passed. You really just want to kind of treat it like it's a separate entity and keep track of what it's doing. Corporate decision making. So we want to make decisions by written consents or by having a meeting and taking minutes. We don't want to just say, hey Bob, want to do it this way? Sure, and then go about doing it that way. This is how a lot of folks do it, but it's best to write it down and sort of observe those formalities. Separate identity. The corporation should conduct business under its own name, not in the names of its shareholders or directors. I mean, it's sort of does it look like a separate entity is the question. If I went around saying, hey, it's Nathan Lawrence Law, and oh, by the way, it's also principal law, that would blur the line. Observance of corporate formalities. If it says you're going to do meetings in the bylaws, do them. If you're going to keep written records, keep them. Follow the operating agreement, and don't make your operating agreement or bylaws more complex than needed, because you'll end up not following them, violating this provision and exposing yourself to liability. And then the last one is arm's length dealings, transactions between a corporation and its owners or others related parties. So I don't want to be doing a lot of business with my other company without formalities. I want to make sure that the terms are fair, that we're not sort of treating it differently. So I mean, what does all that kind of add up to? It's really not as complicated as all this sounds. It's treat it like it's your employer instead of your possession, right? If you treat your business like you're working for it and not it's something you own, then you'll do all this, right? I mean, if you were working for somebody else, you wouldn't go into the bank account and like grab money for groceries on a Tuesday. You wouldn't fire somebody or change the course of business without writing it up. You wouldn't transact in the same informal way. So if you treat your own business not like it's your possession, but like it's your employer, you'll be good. All right. Questions there?
None.
Wow. I must be explaining this really well. All right. Business taxation. So we might actually finish on time or have some time left at the end here. That's exciting for me. That's not normally the case. Again, the form of business you have is determined by state law. How your business is taxed is determined by federal law. There's defaults for each, but you can change that. So if I'm a corporation, my default is taxation under subchapter C of the Internal Revenue Code. That's the one where we have the corporate tax at one level and the tax on the dividends sent to individuals at the other level. I can change that and elect to be either taxed as a partnership or as a S corporation. And back to that question, S corporation is an election to be taxed under subchapter S of the Internal Revenue Code, which is entitled Small Business Corporations. So when people say they have an S corporation, what they really mean is I have a business entity of indeterminate form that has elected to be taxed under subchapter S of the Internal Revenue Code. You can understand why people just say I have an S corporation. In that case, that's a mouthful. But again, it's the point to drive home here is that how you're taxed is a function of federal law, what type of legal entity you have, and what type of business limited liability you have is a function of state law. The default for LLCs is partnership taxation. Default for corporations is subchapter C. Either one can elect to be taxed as an S corporation. All right, talk a little bit more about specific types. So partnership tax refers to how originally a partnership was taxed under U.S. federal income tax law. Remember that there's limited liability partnerships and other limited liability types of partnerships, but again, this term came about when we were talking more about general partnerships, and it makes sense, right? Because we're all just individually liable. We're all just in it together, but it's just a group of people acting. So that partnership as such is not subject to income tax. It doesn't get taxed in itself. Instead, income, deduction, gain, loss, and credits flow through or pass through to the partners who report those items on their individual income tax return. So this is most companies by default. There's no double taxation. We just split up the funds and then we each pay our own tax on it. So the pros, the good side of this, no double tax. You can share personally in business losses. So let's say we don't make money in a partnership. I can take the loss and carry that loss forward into future tax years when I've gained to offset future income. You can't do that in a corporation. A corporation gets to carry that loss forward because it's the one paying the taxes, not you individually. And then flexibility, there's complex but flexible rules about allocating profits and losses. They must meet a test called a substantial economic effect test. So we have to allocate them in some way that has some relationship to the real world. But there's a way that we can say, all right, Jim made a lot of money this year, but isn't likely to next year. And Jane has the opposite situation. So we're going to allocate more losses to Jim this year and more to Jane next year so that neither of them pay as much taxes. It's basically just, there's some tax loopholes you can take advantage of. The cons are, they're personally liable for the taxes. If you're being taxed and it's individual, right? There's no corporate tax, so you're on the hook to pay the taxes related to the income of the business. And that comes in a lot of the time when we were trying to retain earnings, right? So let's say we're in an LLC, we make a bunch of money this year, but we don't want to pay it all to ourselves, right? We want to reinvest in the business. Well, because the corporation or the LLC or partnership isn't taxed in this situation, government's going to tax somebody on that money. Don't you doubt it. They're going to find somebody to get their pound of flesh off of. So that's you individually. So you're going to be taxed on phantom income. If you leave that money in the accounts, government says, well, we're not taxing that entity, so we're going to pretend that you actually got it, and we're going to tax you on it. So what you end up having to make tax distributions just to cover this phantom tax under partnership taxation when there's more than if you don't actually distribute the money, if you leave it in the business. You have to pay self-employment taxes, so you have to contribute to Social Security and Medicare, and also, unless you make an S election, we'll talk about that in a minute. It's all ordinary income. You're not necessarily getting capital gains treatment on the funds that you earn through partnership taxation if you're actually working in the business. It's all considered ordinary income, which can be a disadvantage to small businesses. And finally, if you are going to take advantage of those allocations and deductions, it's complicated. You're going to need help most likely unless you are a CPA.
Nathan, I have a question on that. If you have two partners in a business and they actually each pay themselves through the business, is that a better choice, or is it better to just do the self-employment taxes, or do you have to do both?
I mean, I think it ends up being the same. you're gonna pay like 7.5% through the employer and 7.5% through the approximately as the employee. If it's an employment relationship, whereas if it's not, it's just 15% to the self-employed individual. So I think it's a wash, but that's probably a better question for a CPA. I think what the answer will be is that an S election is probably the best in most situations, which we're going to talk about in a minute.
Thank you.
You bet. Yeah, I'm not a tax attorney, by the way. This is general information. I don't prepare taxes for anybody. I don't fight with the IRS, but I know folks who do. So, corporate taxation. So this is subchapter C of the Internal Revenue Code. Pros, limited liability. You don't have to, if the corporation gets behind on its taxes, that's not on you personally. The lower rate on retained earnings compared to individual tax rates. So it's back to the situation where we have money that we leave in the company. The company is going to pay a maximum, I think, of 21% taxes on that. And that's the highest corporate tax rate, whereas, individual tax rates can be as much as double that. So, if you are going to leave money in the company, it may actually be advantageous to use a corporation and take advantage of that lower corporate tax rate. That corporate tax rate is subject to change depending on who's in control. It was lowered under Trump and maybe raised again, depending. Deductibility of employee benefits, so you can deduct health insurance, etc. Again, with partnership, it's your individual tax, so you can't necessarily deduct those things. The cons are double taxation, which we've discussed, how complex it is. It's really more on the compliance side. Partnerships are more complex on the accounting side, but there's kind of strict rules for how corporate accounting can be done. And then there's limited deductions for the owners. Again, the corporation can take those deductions because it's the one paying the tax, but the owners can't necessarily. All right, so S election. I think this is what most people probably want to talk about. So it refers to taxation methods for small business corporations under subchapter S. They're not subject to corporate income tax, so there's no double taxation. Instead, they have pass-through taxation, but the way it works more or less is you pay, as if you're an employee of the company, you pay yourself that reasonable salary. So let's call it 50 grand a year. You pay yourself a reasonable salary of 50 grand a year. You pay employment taxes on that, and you pay ordinary income tax on that. But with the S election in place, let's say you actually make 200 total. The other 150 is not subject to self-employment taxes, and it's not subject to ordinary income tax. Instead, it'll be taxed as capital gains, basically as investment income that you've returned. So I'm taking my salary, that's what I get paid for my work, and the rest of this is because I own the company, right? And is therefore subject to capital gains tax as if it was an investment rather than wages, which are typically higher. So that's the main reason to do it. The downsides are, there's ownership restrictions, there's strict rules about who can be a shareholder. There's only 100 allowed. You can't have non-resident alien shareholders. You can't have other entities as shareholders. And it can be a little bit complicated to make sure you're following that. But also, unlike a partnership, you have to allocate profits and losses based on the percentage ownership or number of shares. So that can limit flexibility in profit sharing arrangements. You want to have an eat what you kill kind of business with 50-50 ownership. Well, you're gonna have to pay out 50-50 under an S election. So that makes it a little bit more complicated. Now, there are ways to do this at different levels where you have an operating company that is, the one that's paying out the wages to a higher level S corporation that then pays you. So there's lots of ways that you can get around some of those restrictions on S corporations. But you need to be careful and talk to a CPA or a tax attorney about it. I expect we might have some questions on that. No?
I think everybody's waiting until we stop recording.
All right, well, there we go.
Um, I see one coming in. Okay, so here's a question. What are best practices to determine initial percentage of ownership by two founding members of an LLC if one of the members is the managing member? Any common pitfalls of a two-party member managed LLC?
Yeah, you do it 50-50 and disagree. That's a common pitfall, and you don't have, you know, dispute resolution procedures in place. So kind of a few things in that question. It's a great question. First one was there's a managing member, and then a non-managing member. Well, you know, what does that mean? Those two should be, you know, fairly distinct. It sounds probably like there's a money partner and there's somebody who's doing all the work. Now, what we typically see in that situation is the person who's doing all the work becomes the manager. Maybe we have a manager managed LLC where the manager makes all the daily decisions and only the big, you know, do we sell, do we merge, do we liquidate, do we allow new members in? Decisions are joint decisions of both parties, and the daily operations are led by the other one. As far as, you know, what equity split that results in, it's tough to say without knowing a lot more. How much money is involved, how much work is involved, who's putting in what. You know, it's always easier at the end of the day if one party has control. When we do 50-50, there's an opportunity for people to disagree and end up you know, not being able to reach a decision, in which case we typically have a buy-sell agreement or some sort of dispute resolution procedures where one party has the right to buy out the other party. Kind of the last question is, if we do have a money partner and an operating partner, you know, we often see, you know, distinct waterfalls. So like, you know, you get maybe more money after the partner's been paid back, but initially more of the money goes up front to pay back the money partner, the investor. And then there's a premium for that later on after the operation becomes successful. There's a lot of different ways to do it, but I think the pitfall is, you know, you end up in a 50-50 scenario with somebody that you're not confident that you're going to get along with for the next decade or 2 decades, and you have no procedures in place to resolve it when you don't agree on something.
Thank you. And then I have a question. What extra paperwork is required for S Corp? I heard it costs a lot to stay compliant as an S Corp.
Oh, I don't know about that. It's Form 2553 that you have to file with the IRS. You know, it depends on your structure. Like if you have, you know, 120 shareholders and you need to get it down to 100, and you got to do some like corporate gymnastics to make that happen, yeah, that can be expensive. But if there's just 1 or 2 of you and you're, you know, natural residents, and it's not that hard, you know. It shouldn't really be much as far as compliance goes. It's probably something to talk about offline with CPA or with me, or just Google the S election compliance requirements and look at them. And you know, for most of us that have a small business in Colorado, we're already in compliance.
And it looks like you're getting lots of thank yous, but I do have one question, because oftentimes a husband and wife are starting a business and they end up choosing 51% women owned.
Yeah.
Are there, because they're married, what are the consequences of all of that legally and financially?
Well, you know, it depends, of course, Jamie, right? But you know, assuming that there's no premarital agreement in place, right? There's not a prenup already that controls this, then you know, it probably doesn't matter too much that one party has a higher ownership percentage, because you know, when the property if it's acquired during the marriage, then it's marital property in Colorado. And I'm not a family law attorney, so take this with a grain of salt, but you know, if we buy a new house together, it's both of our house, even if it's only titled under my name, right? And so the same is true with all the interests. So maybe she has 51% and he has 49%, but really 100% of it is both yours. So how does that work out? In the long run, it's like, it's likely if you can't get along, it's likely going to be up to the divorce court, how all that works out in the long run. What they would typically try to do is split it up so that, one person retains, like maybe one person gets the company, the other one gets the house or something like that. You try not to, continue to have divorced couples own the same property for obvious reasons, but yeah, legally speaking, is that a problem? Probably not. Just the 51% owner should know that at the end of the day, she probably is still just a 50-50 owner if it came down to it.
Thank you. And Nathan, thank you so much for your contributions to our center and our network and to all the entrepreneurs and small businesses that you support. And
My
I'm
pleasure.
gonna,
Looks like most of you are still awake, so I'll call that a win.
yeah, and lots of compliments in the chat. So we're gonna stop recording in case there's any last minute questions, but thank you, Nathan, for your support.
My pleasure.